That was Bryan Kohberger pleading guilty to the brutal murders of 4 University of Idaho students. Now he says he didn't do it. In a new bombshell court filing, he's claiming he was coerced. Plus,
this is the moment his own signature came back to haunt him. Bryan Kohberger stood in that courtroom, raised his hand, and told a judge, under oath, that nobody threatened him, nobody promised him anything, and he was pleading guilty because he was guilty. 4 life sentences. Case closed. Or so everyone thought. Now, more than a year later, he's filed a handwritten petition from inside a maximum security prison cell claiming the opposite. He says he's innocent. He says his own family and his own lawyers coerced him into a false confession. And he wants a new trial, with the death penalty back on the table.
Bryan Kohberger wants to go back to court because he now says he is actually innocent. Yes, this is not a test. This is not a joke. Bryan Kohberger, after pleading guilty to the murders of 4 University of Idaho students, has filed a petition for post-conviction relief in Ada County.
I'm going to walk you through exactly what he's claiming, why one legal expert says it's basically going nowhere, and why one victim's family is done being polite about it. Let's start with what actually happened. 4 University of Idaho students Maddie Mogen, Kaylee Goncalves, Ethan Chapin, and Zana Kernodle,
who became known online as the Idaho 4, Maddie Mogen, Kaylee Goncalves, Ethan Chapin, and Zana Kernodle, were brutally murdered in the early morning hours of November 13th, 2022. The now famous porch photo, that's what I call it. We've all seen it. It shows those friends happy and smiling just hours before their lives were taken. The small-town police force in Moscow, Idaho, where the University of Idaho is located, had the overwhelming task of tracking down whomever brutally stabbed the 4 college students in their shared off-campus home.
Were stabbed to death in their off-campus home in the early morning hours of November 13th, 2022. A knife sheath left at the scene had Kohberger's DNA on it. His own Amazon purchase history showed he'd bought that exact knife months earlier.
A critical piece of evidence was discovered next to one of the victims. The sheath to a K-bar knife with the U.S. Marine Corps emblem on it. Testing done on that sheath would be the key that would unlock the case. After weeks of investigation, the police announced that they had their man, but he wasn't in Idaho anymore. Bryan Kohberger was back home in Pennsylvania for winter break with his parents. Kohberger was a doctoral student at nearby Washington State University, studying of all things criminology. According to prosecutors, Kohberger's DNA was found on the knife sheath left behind at the scene. His Amazon purchase records also showed that he'd bought that type of knife and a sheath to go with it months earlier.
Weeks later, police arrested him at his parents' house in Pennsylvania, where he was home for winter break from his PhD program in criminology. He fought the charges for almost 2 years. Then, weeks before trial, he pleaded guilty to all counts in exchange for the state taking the death penalty off the table.
Pre-trial hearings and status conferences went on in Latah and Ada counties for months and months. Kohberger and his defense team insisted that he was innocent, but it all culminated in Kohberger deciding to enter a guilty plea. Just weeks before his trial was set to begin, he was sentenced to 4 consecutive life sentences. He's been locked up in a maximum security prison ever since, but now he wants out, and he's trying to take back his guilty plea.
Here's the pattern interrupt nobody saw coming. He never had to explain how he did it.
But in this new petition for post-conviction relief, Kohberger makes a complete about-face, taking back what he said in court last year. This new filing comes 2 days before Netflix is set to drop a new documentary on the case, which features interviews with Moscow's police chief and the family of Kaylee Goncalves. As part of Kohberger's guilty plea, he wasn't required to make a proffer. That's a statement where a defendant lays out facts of the crime. In a proffer, those statements cannot be used against a defendant in court.
Prosecutors chose not to require a proffer, a formal statement where a defendant walks through the details of the crime. Legal analyst Mark Weaver put it bluntly. That's not enough to overturn your guilty plea, but we're getting ahead of ourselves. Let's go back to that plea hearing, because this is where things get uncomfortable fast. Has anyone promised you that I would be lenient or easy on you if you plead guilty? No. Has anyone threatened you or anyone close to you to get you to plead guilty? No. Are you pleading guilty because you are guilty? Yes. Short answers. Clean answers. No hesitation. A judge asked him over and over, in every possible way, whether he understood what he was doing. He said yes every single time.
Do you understand the charges and all those possible consequences?
Yes.
You've heard the plea agreement that I talked about today. Do you agree with that plea agreement?
Yes.
And do you understand the nature of the charges that you've been charged with that I understand you're going to plead guilty today to?
Yes.
As I indicated, I'm not bound by the plea agreement, but the plea agreement is for the maximum on each count. Do you understand that I'm not bound by the plea agreement?
Yes.
Has anyone promised you that I would be lenient or easy on you if you pled guilty?
No.
Has anyone threatened you or anyone close to you to get you to plead guilty?
No.
Has anyone, other than the state's agreements with respect to the plea agreement, has anyone promised you anything in exchange for your plea agreement?
No.
Has anyone told you to be untruthful in answering my questions today?
No.
Has anyone offered you a reward of any kind other than the plea agreement in order to get you to plead guilty today?
No.
Are you pleading guilty because you are guilty?
Yes.
So here's the escalation. It's not just that Kohberger now says he's innocent. It's what he's claiming happened behind closed doors to get him there. In his affidavit, he alleges his defense team and his own family convinced him to falsely confess through coercion, disinformation, false promises, and withheld evidence, including unidentified hair found in victim Ethan Chapin's hands that he says his lawyers never told him about.
Signed by Bryan Kohberger that he filed with his petition for post-conviction relief. In it, Kohberger states, "It is hereby declared that during attorney-client discussions, most of which included all members of Bryan C. Kohberger's immediate family, petitioner was convinced to falsely confess to capital murder and felony burglary by coercion, disinformation, false promises, and the withholding of exculpatory discovery. The following is material to the inception of the plea. Counsel's failure to inform petitioner of exculpatory discovery he received during plea discussions, namely clumps of unknown hair found in Ethan Chapin's hands, as well as a failure of further inquiry. Number two, petitioner was convinced that actual guilt was not an important factor in considering a plea acceptance. Death row was imminent and advised to lie. Petitioner was to get a legal victory in entering a false plea.
He claims he was told death row was imminent, and that pleading guilty was somehow legal victory. He even claims his lawyers told him and his family an elaborate, frightening story about touring an actual death row cell, used, he says, to scare him into signing.
Number three, a gross misrepresentation of and promises regarding what a life sentence would immediately afford petitioner, and a gross misrepresentation of death row in Idaho, including an elaborate story of counsel's horrific experience touring an actual 8x8 death row cell, all communicated to petitioner and his family, allegedly by IDOC through counsel, thus constituting threats and promises made to induce a plea agreement.
Small lie, now a pattern. Now an accusation that could take down his entire legal team. Prosecutor Bill Thompson was asked directly why they never pushed for a proffer, why they never made Kohberger explain, in his own words, where the knife went, how he moved through that house. We wanted to make sure that the guilty plea itself was solid.
You know, I asked you this at the press conference. You said under the law, you can't be compelled to force him to allocute. But why not get a proffer from him? You know, hey, Ann, like we'll let him plead, but we need to know where he put the knife and how he got through the house and everything like that. Answer a few questions. Why didn't you ask for a proffer?
Well, we talked about that among the attorney team, and we made a decision that we wanted to make sure that the guilty plea itself was solid if he was going to plead guilty. Our experience, and Judge Hippler talked about this as well, is that frequently when defendants are being asked to explain, they start to minimize what occurred. They can't be trusted for the truthfulness of what they say. And we elected, in order to ensure a solid, sustainable guilty plea to all the counts, that we would not press for more than what the court was going to require as far as the defendant admitting to the truth of the charges.
That's it. That's the whole justification. And here's where it gets darker. Thompson revealed that FBI behavioral analysts told investigators early on that even if they got a confession, it wouldn't make sense to normal people because, in their words, people who commit crimes like this live in their own different world. Let that sit for a second. The FBI told prosecutors before any plea deal that this person couldn't be trusted to tell the truth, and then they built their entire case resolution on him telling the truth exactly once in a courtroom under oath. Now here's your sympathy beat, and it's not who you'd expect. It's the Goncalves family. Kaylee's family didn't hide behind lawyers or legal jargon. They posted directly raw, unfiltered, clearly exhausted by a process that's already stolen years of their lives. The mosquito you just can't seem to swat. That's what they called Kohberger and the online following defending him.
Goncalves' family statement states, the mosquito you just can't seem to swat. That is what Kohberger and his following have become to this family. We read Mr. Baker's story, and he must be so proud of himself for speaking with Mr. Kohberger, because the story didn't have much else in it other than a guilty man claiming he is innocent once again. Nothing in the story or in Kohberger's statements does he allude to the fact that he did not knowingly, voluntarily, and intelligently admit to murdering the 4 victims of this tragedy, Kaylee, Maddie, Xana, and Ethan. Quite to the contrary, he appeared in court in a hearing in front of a judge with his 4 lawyers. He did this after deciding not to leave his fate and the facts of the case up to a jury to decide his guilt. He never cried wolf or claimed he was uninformed, pressured, or that there were issues with the discovery that he and his counsel had for 2 years that he thought should have been challenged. He admitted to guilt and asked whether he actually was guilty. He said, yes, I am sure there will be a hearing, as that is how the legal process works, and the defendant will get another day in court.
They wrote that he never once, during his plea, claimed he was pressured or uninformed. He answered every question. He said yes when asked if he was guilty. Now, over a year later, with a Netflix documentary about the case dropping in days, he's rewriting history. And they're the ones left reliving it. Regardless of how this turns out, our family is 100% ready. An actual trial this time. Let's go. That's not confusion. That's not naivety. That's a family that has been dragged back into a nightmare they thought was finally behind them, bracing themselves all over again because one man doesn't want to sit with what he did. Now, let's talk about why this almost certainly fails. Because Mark Weaver did not hold back.
Yeah, remember, every defendant in prison has 2 things: a lot of free time and access to a free law library with lots of forms that they can fill out to file things. And so that's why we have so much prisoner litigation. I don't think this is going to go anywhere, but we can certainly analyze it.
Remember, every defendant in prison has 2 things: a lot of free time and access to a free law library. He walked through it point by point. The window to file a normal motion to withdraw a guilty plea closed months ago, back in September. That's gone. What Kohberger filed instead is called postconviction relief, and the bar for winning one is brutal. He has to prove his lawyers were so ineffective that he genuinely didn't understand what he was agreeing to when he stood in that courtroom.
Yeah, let's unpack it. First of all, when you plead guilty, you give up most of your appellate rights. That's different than if you go to a trial and the jury convicts you. There's a different array of appellate rights available in that case. So when you plead guilty, you are giving up a lot of appellate rights. Second of all, there's a 42-day window in Idaho when you have to file your motion to withdraw your plea. That came and went last year. So he can't file a typical motion to withdraw a guilty plea, even though those rarely work. He's left with what we call PCR, post-conviction relief. Most defendants file motions for post-conviction relief. Rarely are these things granted. The standard was the representation by his defense counsel so bad, so ineffective, that when he was answering questions with the judge, that he didn't even know what he was being asked. It's probably not going to be granted for a couple of reasons. One is I didn't like his lawyers very much, but they were pretty effective. They got him off the death penalty. And number two, if there's anybody who ought to understand a judge's questions, and I sit as an acting judge sometimes when the local municipal court judge is out on training, so I've done thousands of these, the judge has to ask the defendant a question over and over again. Do you understand this? Do you understand that? You're giving up this right. You're giving up that right. If there's anybody who understands that, it's someone in a PhD program for criminal justice. So the notion that he didn't know what he was doing, rather far-fetched.
Here's the line that should end this whole conversation. If there's anybody who ought to understand a judge's questions, it's someone in a PhD program for criminal justice. Weaver didn't even pause after that. The notion that he didn't know what he was doing, rather far-fetched. And there's a deeper problem buried in Kohberger's own argument. To claim ineffective counsel, he needs different lawyers than the ones he's accusing. The same lawyers who allegedly coerced him can't turn around and defend that claim on appeal. So now we're left wondering, is this really him, alone in a cell, or is someone else quietly building a legal strategy behind the scenes? Weaver raised something else that's been sitting uncomfortably with a lot of people. Kohberger's own defense team spent months raising questions about his competency. They pointed to a diagnosis, level 1 autism, what used to be called Asperger's. And yet the same lawyers who monitored his competency never said a word publicly when he suddenly filed this petition claiming a completely different version of events.
Regardless of how this turns out, our family is 100% ready. An actual trial this time? Let's go. We are confident he will get the death penalty that he escaped by pleading guilty the first time around. Moving on, LOL. Just an absolute waste of time and taxpayers' money. It's a disgrace. I guess I better get me a death row record shirt for every day of the week now.
So watch for two things next: whether a judge grants a hearing on this petition at all, and whether Kohberger's family manages to bring in outside legal counsel to actually litigate this instead of him filing it alone. Because right now, this is one man against his own signed confession, and we're about to find out if a law library beats a courtroom.